Hi, my name is Lorenzo Azar Banks here on behalf of Minority Report Law Office here in Oklahoma City. And today I'm doing another video response to a question that we had asked of us, and the question goes something like this. I bought a car, and within hours I realized that this was not the car for me for whatever reason, and I want to return the car. Isn't there a 3-day grace period in Oklahoma that allows me to return a car and get a full refund? No. I'm sorry, but more than likely in the state of Oklahoma, once you sign on the dotted line for a car, congratulations. You are now the owner of a new car, and there's very little wiggle room to get out of it. Let's understand this common misconception here in the state of Oklahoma. What I think we're getting confused on is the Federal Trade Commission's cooling off rule. The Federal Trade Commission is the federal administrative agency that is responsible for preventing deceptive or anti-competitive business practices of businesses here in the U.S. And to do this, they make rules. And one of the rules they created was the cooling off rule to protect consumers in door-to-door sales. The FTC defines a door-to-door sale as this: any sale for $25 or more that is initiated by the seller, and the sale takes place either in the buyer's home or in a place that is away from the seller's regular or permanent place of business. So you'll see this most often in instances where you have actual door-to-door salesmen, or when you've got salesmen who are renting facilities, who are renting a tent, who are renting a booth, a building, someplace other than where they normally conduct business to sell their goods or services to you. A good example of this is all of the vendors that you see at the fair are considered door-to-door salesmen under the FTC's definition. And so these are all door-to-door sales, and the FTC cooling off rule says this: that for any door-to-door sale, the buyer may cancel that sale if they cool off or if they ask for a refund or a cancellation of the sale within 3 days of signing on the dotted line to make the purchase, and they will be eligible for a full refund. There's the rule, plain and simple. Here's the problem. Because later on in the rule, the FTC goes on to say that the cooling off rule does not apply to sellers of automobiles so long as they have one permanent place of business. So if you see what I'm leading you here, that automobile sales don't fall within the purview of this rule, and it's your least likely weapon to find yourself getting out of a contract for sale of a vehicle here in Oklahoma. So some things we want to take away from this video. To protect yourself best in these type of situations, read the contract before you buy the car and make sure that there is a return and refund clause within the contract, because that's going to be your strongest weapon in being able to get out a contract for sale of a vehicle here in Oklahoma. Secondly, you may be able to get out of a contract for sale of a vehicle here in Oklahoma if in fact the car is deemed to be a lemon under Oklahoma's lemon laws. Now, Oklahoma lemon laws are a whole nother can of worms that I plan on opening in another installment to this Oklahoma car law series, so please stay tuned for that so I can inform you about those laws as well. Once again, my name is Lorenzo Azar Banks here on behalf of Minority Report Law. You can reach us at minorityreportlaw.com or catch us on our Facebook page at facebook.com/MRLawOffice. Post your questions there and like us so you can keep up with our videos that we're posting. So hey, you now know the information. Go on out to the car lots and buy your car, but go armed with knowledge. I hope this helps. We'll see you next time.